Welcome back to the Crypto's Key conversation. This one's going to be fairly short. We want to go over this massive update that's going on with the Ripple versus SEC case. So, looking over here, James K. Filan says, breaking, the court has denied the SEC's motion for reconsideration of the DPP ruling and granted the SEC's request for clarification of that ruling. Coming out here, he continues, says, quote, the SEC has identified no intervening change of controlling law or any other controlling decision unaddressed by the court's January 13, 2022 order. Quote, the SEC's assertion that the speech was intended to communicate corporation finance approach to regulating digital assets offerings is inconsistent with the SEC's and Hinman's previous position that the speech was intended to and did reflect his personal views. Quote, the SEC seeks to have it both ways, but the speech was either intended to reflect agency policy or it was not. Having insisted that it reflected Hinman's personal views, the SEC cannot now reject its own position. This is a very big win for Ripple. The SEC has 14 days to file an objection to this decision to District Judge Torres. So this is a huge positive that's going on with the Ripple versus SEC case. Absolutely massive. And I strongly think that they will, have this 14-day period to where they do have an objection just to continue on their delay tactics within this case, because they know, the writing's on the wall when it comes to it. They're going to lose this case, so they're going to delay it as much as possible. Coming down here, I wanted to bring this up. I think this is the one I wanted to bring up. It says, so this gentleman was talking about they want to make some content. They don't want to mislead. Says ultimately it's about the Hinman emails and whether his speech was his opinion or that if the finance division at the SEC and the judge has rules, it's his own. It's his opinion. Essentially, Jeremy Hogan says basically yes. She's saying that there were no SEC deliberations taking place in the emails because everyone was just discussing Hinman's own personal opinion. And so no deliberative process privilege or DPP to apply. She did not allow them to back on the narrative they wove. XRP Crypto Wolf says, Ripple is that much closer to winning the XRP lawsuit. Absolutely. James K. Filan and them said, though, we still got some more time in regards of, this thing kind of rolling out, unless, a settlement comes like, within 90 days, like Johnny Didnt talked about. But anyways, Jeremy Hogan says Judge Netburn sticks to her guns on the DPP issue and reorders the production of the emails related to him in speech. The order includes some uncharacteristic SEC chastising from our judge. I'm mirroring her in stating that I'm mirroring her in stating that as politely as possible. So coming down here, you can take a look at this. I'll bring this up so you can pause it. Take a look at it if you want. Coming down here, it says the order is a little concerning because she allows redaction of parts which discuss separate agency deliberations. My concern, and this is from Jeremy Hogan, says it's those part of the emails that are most damaging to the SEC. How will we know? If the SEC appeals up to Judge Torres, they are in trouble. So that's a great point. Like if there is going to be parts that are going to be allowed to be redacted, like how we know those aren't going to be the smoking gun or the, like he says, the most damaging parts of, what the SEC's done, what they're trying to hide, which can be one of the most dominant, pieces of evidence within Ripple's position in the case. That's a great point there. This is pretty funny. Ripple Effect says, I don't know who slapped harder, Will Smith or Judge Netburn. Jeremy Hogan says, I wish I had thought of that. Laugh out loud. So coming over here, Johnny Deaton says, this is not just a win for Ripple and XRP holders, but for the judicial system. After the March 2021 hearing, I said we were lucky to get Judge Netburn. Some of you disagree, but I still believe it. The SEC is now officially in a hurt locker. I 100% agree. And Johnny Deaton's been all over. He's literally put the dart right there on the bullseye. I wanted to bring this up. This is Johnny Deaton. He's talking about a few observations based on kind of everything that's just rolled out recently. He says, 1, I was wrong before when I said there were 52 drafts of the Hinman speech. The judge writes, as evidenced by the 68 drafts. Keep that in mind. Not 52, 68 drafts and associated commentary in the SEC's privilege logs. So just think about that. If there's 68 drafts, how many emails are we talking about? You could be potentially talking about, hundreds of emails being passed back and forth if there's 68 drafts, which is crazy. So anyway, 68 drafts with lots of commentary. There's a strong chance XRP is mentioned. Absolutely. Are you kidding me? I mean, think about everything Joe Lubin and them been talking about in all these interviews when they're going out and gloating and talking about this free pass they got. They're literally almost always, and I say almost always, respectively, talking about or comparing to XRP, which is crazy. So someone somewhere had to mention XRP, which would be very damning or damaging. He says, too, Judge Netburn added a bulletproof section for any appeal to the Second Circuit. She could have flat out denied the motion of reconsideration pursuant to Rule 6.3. Can't raise new arguments you did not the first time. Instead, she recognized how important the DPP doctrine is. So I'm going to click on this so you can pause it and take a read and look at what he's talking about in the notes. He continues, she didn't just summarily deny the motion, but analyze the SEC's substantive DPP argument with and then rejected it. Excuse me. So she did not just summarily deny the motion, but analyze the SEC substantive DPP argument and then rejected it. I love it. What she did was take away any argument on appeal based on how important DPP is, in that the judge didn't consider it like she should. Can you say brilliant? So absolutely. 3, she called out the SEC for its inconsistent positions related to the speech. She said you don't get to change your position just because you didn't like the court's conclusion. She highlighted the inconsistency by drawing specific attention to Hinman's under oath testimony, which is a crazy scandal and lie in itself. So anyways, 4, she threw a bone to the SEC by clarifying the SEC could seek leave to redact those communications from its production that implicates other separate agency deliberations, not deliberations about the content of the speech. So you can come in here, you can pause and read through these notes as well. Then he goes, on one hand, this is good because it makes this order bulletproof. Any appellate court will see the judge in honoring all privileges under the law. This is no way, in my opinion, Judge Torres or the Second Circuit disturbs Judge Netburn's ruling. On the other hand, what exactly does separate agency deliberations mean? That's what Jeremy Hogan over here was just talking about, his concern. So yeah, well, what does that absolutely mean? We would know what she means if we had access to comment 12 on page 6 of the speech draft in document J. In other words, she gave a specific example of what can be redacted by the SEC. And then he ends here. He says, SEC is not allowed to redact agency staff communications about edits to the speech. And the edits themselves can be redacted. The judge will review the proposed redactions. If XRP was referenced in the 68 drafts and or in the commentary, Ripple gets it and XRP wins. On that, I mean, that would be absolutely massive. You talk about a bombshell and, a major strength in Ripple's position in the case. I mean, just getting access to the drafts. Think about how much we found as Twitter people and YouTubers on the internet, coming together in a decentralized collective way, to fight the good fight. Look how much we have surfaced. Imagine what's, being spoke about or being, written about within these documents or within these drafts. These emails being passed back and forth, all these different governing members or whoever was involved in these sending these drafts around, their names and what they're saying and their thought process on things. There can be so much information that can be pulled from that to strengthen this Ethereum free pass timeline, the ETHgate scandal stuff, and the position of Ripple within this SEC versus Ripple case. Absolutely massive. Now, to not be a negative Nancy, but I liked what digital asset investor said here. He says, I repeat, we never going to see those Hinman emails. I believe this much worse than we think. So quite honestly, I agree. I'm leaning towards that narrative more than the latter, because if there's really, damaging, information in there, especially in regards of, the SEC being a part of this ETHgate scandal, this Ethereum free pass scandal, trying to create that monopoly for, Ethereum and so on. And especially the people that maybe have been involved with, being a part of these 68 drafts, I highly doubt that they ever want that stuff to surface. So my thing is now, so is John Deaton's right here, this person saying it right here, is John Deaton's position in regards of if there's a settlement, there's a good chance it's going to be within 90 days. We'll see. I don't know if it's 90 days from after this 14-day period when they're going to, appeal it up to a judge or judge. I think they said Judge Torres. I don't want to get that wrong. Yeah, 14 days for filing an objection to this decision to Judge Torres. Yeah, so is it, 90 days after that or 90 days after the Judge Torres comes back and denies it? Who knows what the case is. I just wish we knew, like, obviously we have a certain timeline. I think they were talking about, like, November being the latest or something, but I wish we knew, where this thing was going. And truly, if settlement has been in the talks and it comes sooner than we think. Just a waiting game. Jeremy Hogan said it best. He said it weeks ago that, hey, the next few months are going to be quite interesting within this Ripple versus SC case. So I'm interested to see where things go. Obviously, we should be very proud of ourselves as a decentralized community, whether you're an XRP holder or believer or not, like to come together to try to fight the good fight and support one another and, hold the, our government, especially the SEC and, all parties involved in this ETHgate scandal and Ethereum free pass, like hold them accountable. This is absolutely massive. This is what cryptos is about, coming together as a decentralized community to fight for a common cause and for the health of our market. With all that being said, stay strong out there. Be safe.